SJC-13579 in the matter of trust of Helyn Kline for Denise Joe Levy.
Okay, Attorney Taylor, whenever you're ready.
Good morning, Your Honors. May it please the Court, Attorney Tracy Taylor for Peter Judson, the appellant in this matter. I want to start out by addressing two key points which I feel may not be explicitly clear from my brief. The first is that the Massachusetts Principal and Income Act, which I will refer to as the MPIA, is by definition, and this is set forth in Section 3A of the Act, a default act. By its terms, it only applies, strike that, by its terms, it only applies when there is no contrary provision in the trust itself, or when the trust itself does not grant the trustee a discretionary power to administer the trust.
I take it that what you're pointing to for this proposition is Section 3A?
Yes, Your Honor.
Okay, so I was going to ask you about that. Which of the four subsections of 3A do you contend this situation falls under?
I believe it's Section B, Your Honor.
No, I'm asking about 3A, which has four subsections, not B. We don't get to B yet. So
It's Section 3, Your Honor.
3A what? There's four subsections. I don't mean to quiz you off your memory because I'm holding it in front of me, which gives me an advantage. So
I
if
believe
you
it's
need
Section 3A3.
Okay, so
It's a little confusing the way they're all set out. But
that okay, I want to make sure. So 3A3 says that in allocating receipts and disbursements to or between principal and income, a fiduciary shall administer a trust or estate in accordance with this chapter if the terms of the trust or the will do not contain a different provision or do not give the fiduciary a discretionary power of administration. So is that the provision that you're relying on?
it's 3A3.
3A3. Okay, so that is.
Yes.
So as I read that, and correct me if I'm wrong, you're saying that the will, the testamentary trust,
Yes.
did not give the trustee discretionary power to allocate between principal and interest, correct?
It gave the trustee discretionary power to allocate between principal and interest, but only under the most extreme circumstances. The settler's intent.
So they do contain a different provision.
That's exactly right,
All
Your
right,
Honor.
so-
My error and my nervousness, I
No,
quoted the
no,
wrong.
so that's okay. So 3A3 then says that they will, in those circumstances, they will administer it in accordance with the MPIA,
Yes.
that they shall.
They shall if it does not contain contrary provision. And my position is that the will does contain a contrary provision.
So really, you're going, and this is again unfair because you don't have the statute in front of you, but it's 3A1.
3A1, thank you.
Which is-
I
it
also
says
can't
that-
see in my old age, so things are,
Don't we all?
3A1. And exactly, this trust is unique. First of all, it was created back in 1977, which is well before the Uniform Principal and Income Act was enacted.
Is it your position that the statute doesn't apply because of the 1977 execution of the will?
Nope, I believe Massachusetts Principal and Income Act, well, if you get to the point, if you decide that the settlor's trust does not contain a contrary provision, such as the MPIA does apply, then we get to the argument of whether or not the trustee applied Section 3B of the Act, which is the duty to apply the power to adjust impartially, and my argument is that it does not. But my reason for talking about the date that the trust was created is that the UPIA and the MPIA, MPIA were not in existence at that time. So the way the trust was written, the settlor was not anticipating these things to occur. So she says explicitly in
that's not
section-
exactly true, right? Because there is still this ability for the trustee to do this. You're arguing the emergency circumstances component, right? Because the trust document still gave the trustee the right to change these allocations.
The trustee does have that power
Right.
through the will, but only under a showing of emergency
Sure.
circumstances.
Can I just want to just make sure I have this right? Is the increase here that your client is objecting to, was it about $25,000?
Over the course of the past 5 years, it's more in the neighborhood of $276,000, Your Honor.
Okay.
And the trustee has been, since at least 2018, liquidating the principal of this trust, which I suggest to you is not invested in growth stocks. Rather, it's invested solely in dividend-bearing stocks and interest-free municipal bonds. So my argument
That
is...
in the record?
I'm sorry?
I didn't see that in the record.
That may not be in the record, Your
Right,
Honor.
so
That's
we can't consider it if it's not in the record.
understood, Your Honor. The argument is that
Although the record does show that the value has gone way up, right?
Considerably.
it does not say that, Your Honor. It gives you a value of the trust as of 2021. What is missing in this case, and that's my argument, is if the MPI is going to apply, if you get past the words of the settlor in the trust that say only under emergency circumstances, upon examination of the income beneficiaries' assets and income,
Wasn't that in the summary judgment record, though? Because wasn't there some kind of evidence from the trustee that he had run this math?
No, there's not.
There was
Well,
an
the
affidavit.
There was an affidavit.
affidavit that talks to the amount, the value of the trust, but what I'm suggesting to you is missing, and I would refer...
No, not the value of the trust. That he looked at the income beneficiaries' liabilities, bills, whatever it is, but that there was some analysis of the amount that the trust had grown versus the fixed amount that she was getting in income over the years, and that it was disproportionate, and it needed some kind of recalibration based on her changed circumstances.
There is a very self-serving blanket statement to that effect by the trustee, Your Honor, but I'm suggesting to you that what is missing...
Is it under oath?
It was an
Okay,
affidavit.
so it's evidence on summary judgment. What's the contrary evidence?
The contrary evidence is the...
You can't just say he's lying, right? You have to come up with something.
Exactly. The contrary evidence is the affidavit of the appellant, Peter Judson, who says that his mother told him that she was doing very well. She had realized $1 million from the liquidation of one of the other family's trusts, one of the other family trusts, and that she had earned considerable money and was making considerable income on it and was not running debt. So
We have an affidavit of the mother?
there is no affidavit of the mother.
Okay.
She did not file an affidavit of objection. She objected, but she never filed an affidavit of objections in this case.
Right, but how are his hearsay statements of what his mother said admissible?
I don't
there
think I
deposition
even need to
testimony,
get to this
anything?
argument, because what I'm really contesting here is if you get past the settler's intent that says only under an emergency, and you get to the application of the MPIA. The MPIA was enacted in response to the adoption of the Prudent Investor Act, which gave, for the first time, trustees the ability to maximize the overall growth of a trust at the, potentially sacrificing the income beneficiary's rights.
I have a couple of questions that are driven by the specific language in the will. So you may want to look at them if you want. The first is, the will uses the term distribution or distribute, and it also uses the word adjustment, allocate, or apportion. And those are not synonyms, correct?
They are not, Your Honor.
Right. So can you please tell me your view of what is the meaning of distribute or distribution? And then separately, what is your view of the meaning of adjustment?
And this goes to the appellee's argument, where they argue that there is the prohibition against distribution does not equate to a prohibition against adjustment.
It's not really about an argument. I'm trying to get it because those terms, definitions, must mean something because those terms appear in the portions of the will that you're relying on.
Okay, so then adjustment would mean reallocating capital assets to principal.
Okay.
To
And
income.
distribution means?
Distribution would be paying out those,
Okay.
and that's what has
So-
happened in this case.
Well, hold on, because those are two separate acts. I agree. You can have an allocation, a reallocation, or an adjustment, and then the distribution gets made, right? The distribution is actually when the race is transferred out of the trust to a beneficiary. Am I correct on that?
Correct, and the
Okay,
trust.
so let's look at page 47 of the record appendix.
Okay, I'm there.
This is the last paragraph of section 7th. So it's the first full paragraph on that page, 47. Now, this paragraph, as I read it, doesn't have anything to do with distributions, correct?
Paragraph 7th, Your Honor?
No, the last paragraph of paragraph 7th.
Last.
So it's on page 47.
Starts with my fiduciary in their absolute discretion shall have the authority to claim items. Do you see that?
Yeah, what article are we on?
Look at
7.
Article 8th. If you look at Article 8th and you look at the paragraph immediately
There I am.
above,
I have my pages,
that's okay. Immediately above paragraph 8th, I'm talking about the
Sorry,
47.
The record appendix.
Article 8th.
And just look at the paragraph above where Article 8th starts.
Okay, so you're looking at Article 7th, okay.
Right, the last paragraph of Article 7th.
Well, I'm glad you actually raised that, because I wanted to get to that, and that's where I was trying to head when I said that this trust was created prior to the enactment of the MPIA.
But can we
And
agree
back-
that this paragraph indicates that the fiduciaries will have discretion to make adjustments or apportionments among the beneficiaries or as between principal and income?
And I would argue to Your Honor that, yes, it does that solely in the context, you have to read that in the context of the entire article, which talks about estate, succession, transfer taxes, and income taxes. And as I was saying, this trust was created prior to the MPIA when accounting principles for trusts were far different. Prior to the enactment of the MPIA, you took deductions from income and stayed with income, and deductions for principal stayed with principal.
Yeah.
So that paragraph that we're just reading,
So if it does give them discretion in that regard,
it gives them the discretion
then how
because,
is it that this case doesn't fall under Section 3A2?
if I may address the Article 7 first, Your Honor, this article that we're talking, this clause that we're talking, this paragraph that we're talking about that gives the discretion to apportion is done so for the express purpose of maintaining net income for the income beneficiary. Because if you did not have that clause in that section, the trustee would have had to deduct income taxes from income. This is giving the trustee the actual ability to maintain net income for the income
So
beneficiary.
the judge erred in relying on that, you're saying, I take it. The judge, because the judge bases her decision, I think it's her decision on this, right?
She did.
Yeah. Can I
But
ask
she-
one thing? I don't know about the others. My page 46 is completely illegible.
It just goes from 45 to 47.
47.
Okay, it's just,
Yeah.
all right. Okay, so this thing, in your view, is a red herring. It's just a income tax.
It is, because it applies to the accounting principles for trusts that were in effect when the trust was created. Those principles were changed by the enactment of the MPIA. We didn't have those principles. The trustee, back when this trust was written, was not allowed to deduct income taxes from principal. So the effect, if you had not included that language in Article 7, net income would have decreased.
So if the trust did give, or if the will did give the trustee a discretionary power of adjustment or allocation between principal and income, why does this case not then fall under Section 3A2 instead of 3A1?
It falls, I think they're both equally applicable, Your Honor. They
Except
both-
that the outcome would be very different.
I don't believe the outcome would be very
Because
different.
3A2 says that if the trust gives a discretionary power of administration to the fiduciary by the terms of the trust or the will, which this paragraph does, then you would apply the terms of the MPIA, even if the outcome is different, then the result would be even if the outcome would be different.
I still think we have contrary provisions in the will, but even if you get beyond that and you apply the MPIA, Section 3 of the MPIA, 3B, says the trustee has the duty to apply the power to adjust impartially and in a method that's fair to all beneficiaries. And I would direct your attention to the comment to the UPIA, which I believe is at page 116 in the appendix, and the second full paragraph there, which makes it explicitly clear that these acts were enacted as a response to the Prudent Investor Act, which allowed the trustee to then grow principal without regard to the income beneficiary's rights. So the comment to the act makes it clear that in order to apply it impartially, in order to apply the power to adjust impartially, you can't just say, oh, the trust has grown and the income beneficiary's rights, income has not kept up. You need, and this is, goes to the example 4 under the comment, which is exactly on point in this case. You
Well,
need
it's
to
not,
show,
excuse me, it's not exactly on point because that example contains a 6% ceiling,
correct.
which you don't have a 6% ceiling here.
no, but you could infer that when the rate of income that the income beneficiary was receiving at the time that the trust was created, at the death of the testator, that if you're going to utilize the power of adjust, the trustee would need to make a showing that he has made a change in investments. And I would suggest to you we do not have any evidence here that that has occurred. He needs to make the showing that he made a change in investments to benefit the full value of the trust and that the income beneficiary's income has decreased. We don't have either of those things.
So on that first point, reading through the committee report behind the legislation, it seemed like there were actually two financial circumstances that they were focused on. One, the one you raised, that you want to manage for growth, et cetera.
Exactly.
But secondly, that top-performing companies simply aren't paying dividends in very often anymore. And in fact, even if you don't make a change in the investments that may have been held for a long time are just no longer yielding dividends. So is there a basis in the act that the trustee would have to have actually changed? You're claiming that the trustee would have had to change the investment allocation. Is there a basis for that in the statute?
I'm basing that on, yes, that the section that says that they are complying with the Prudent Investor Act. And they have to make a showing, the trustee has to make a showing, the trustee has to keep records as to how his changes in investment strategy, or even to give Your Honor's argument its due, that principal increased by X amount over the course of the years.
Well, Counsel, I'm going to interrupt you before we lose you, because I know you might disagree as to whether or not the co-trustee did any of this. I read it in the record that he had made these determinations about the investments and as to why he did the allocations the way he did. I'm trying to kind of zero in on what your point is. Is it that summary judgment was wrong here because there's a factual dispute, or because you claim the judge made an error of law?
I claim the judge made an error of law, Your Honor, and that she completely ignored Section 3A of the MPIA.
So
She
what
didn't even get there.
what are we to do with your saying that there was a counterfactual affidavit from your client saying, I heard all of this stuff from my mom, that you know she had done well, and that the concerns of the co-trustee about reallocating because of her personal circumstances weren't founded?
I don't think we even need to get there, Your Honor, because I think the crux of the argument is the lower court ignored Section 3A. They had a misreading of Article 7 because the court didn't understand that that language pertained to trust accounting principles that were in effect at the time, which have now changed with the inaction of the MPIA.
Okay, thank you very much.
Thank you, Your Honors.
Okay, Attorney Lindstrom.
Good morning. Thank you. Christopher Lindstrom on behalf of the appellees and trustees. So we have two issues presented on this appeal. First being whether the probate and family court found that Attorney Friedman had the right, the authority to adjust as between principal and income under the Principal and Income Act. And secondly, if he did have that power, was there any evidence in the record to show that he abused that discretionary power?
Why do we keep thinking of this as or at least you do, I think, that the trustee can act unilaterally? I didn't see that in the will. I thought that this was a testamentary trust that appointed multiple trustees, and it did not say, I didn't see a provision, and no one cited me to one, that says that each trustee can act unilaterally. Is there one?
But there was that provision, if you are a beneficiary and co-trustee, that you're accepted out.
Correct. So the trust sets forth that it is intended to have at least two trustees at any given time. But then, as Justice Georges points out, there is the separate provision, Article 8, which states that if you are a beneficiary, you are not to make a decision that may impact you.
Okay.
And therefore, the co-trustee, excused herself from this decision, and Attorney Friedman, as the unbiased trustee, made the decision on his own.
And he does so based on the fact that the principal has gone up a lot, right? And that the income is not rising accordingly. Is that a fair statement of that? Because I'd like you to finish your point about why is this right? Because I don't think it's right because of the tax provision flexibility, and nor does it appear that you think it's right because it's your last argument. So tell me why the judge got it right besides that.
Sure. Respectfully, Judson's entire appeal here is premised on a fundamental misunderstanding of what the power to adjust under the Principal and Income Act really is. Judson appears to be equating the power to adjust to the power to invade principle, which is when a trustee looks to the circumstances of the income beneficiary and decides to, quote unquote, invade the principle to make a distribution based on current needs, emergencies of the income beneficiary. The power to adjust is a completely separate tool. It's well recognized now in the trust and estates community that permits trustees to correctively adjust as between principal and income when investment strategies have led to comparative allocations between the two that no longer treat the principal beneficiaries and the income beneficiaries the same.
So Article 7 of the will expressly gives the trustee the power to adjust between principal and income for tax purposes. So I'm with you to that point. And then what happens under the MPIA?
The MPIA is clear that if there is no language speaking to whether the trustee has the power to adjust, then the trustee has the power to adjust. In other words, there needs to be...
But there is language in Article 7, and so, I get it when there's no language, then the MPIE gives the power to adjust. When there is language for tax purposes, let's just say, what happens?
It only bolsters argument that the settler's intent was to provide the trustees the discretionary authority to adjust or allocate when circumstances made it necessary to treat everyone equitably. Now remember,
So are you under 3B now? I'm confused as to where the MP...
Which 3A subsection do you believe this case falls under?
that it is a default act unless there is contrary language in the trust.
Why isn't the extraordinary
that's
circumstances language applicable? I'm confused by that. Because you're allowed to do this if there's extraordinary circumstances, but isn't that a provision saying, isn't that implicitly that you're not allowed to do it if there's not extraordinary circumstances?
Well, respectfully, I disagree.
I just don't know the answer. I'm not putting a position out.
When you, within your question, you say the ability to do this. And what I'm saying is there are two different thises.
Okay.
There's the power to distribute through an invasion of the principal when there are these special circumstances, these emergencies, these dire circumstances. That's different than here, the power to adjust under the Principal and Income Act. The power to adjust is a reallocation based on, as you pointed out earlier, investment decisions under the prudent investor rule that have grown principal in a way where income is not. Now remember when this
grown principal is not invaded principal, that when principal grows, you're not invading it. Is that clear? Again, I'm not a trust and estate expert by any means. So
it is clear in the comments to not only the Massachusetts Principal and Income Act, but also the Uniform.
But counsel, the comment, oh, sorry, go ahead.
And that's actually how she uses it in her trust, right, in her will. She separates between distribution of principal, which is only for emergency situations, and reallocation as between principal and income for tax purposes.
Correct, yes.
But the example that has been cited specifically contemplates, I forget what number it is, example 4 or something, specifically contemplates that a trustee will, and admittedly it includes the 6% in that hypothetical ceiling of 6% distribution, but it contemplates that a trustee will actually keep track of how much the current beneficiaries have lost out as a result of the investment strategy. And Mr. Friedman's affidavit here does not contain any of that information. It just simply says, I've been, in a conclusory fashion, I have been investing as a prudent investor and the income has not kept pace, so I'm giving her approximately 1% more. Do you think that it doesn't seem to exactly fit with the level of of detail contemplated by the act.
Well, first of all, the comment number 4, which is you exact on the number, I'd just like to point out that that absolutely shows that Attorney Friedman had this power to allocate. Because in that comment, it clearly distinguishes between the power to invade for distributions, and even if there is a limitation on the power to invade, the comment states that the trustee still has the power to do this power of adjustment under the MPIA. Now, or in that case, the Uniform Principal Income Act. To your point, the 6% is the key.
Can I ask one, I just want to make sure I understand.
Can we have an answer to Justice Stewart's question first, though, please?
So to me, the 6% is the key, because we don't have that similar situation.
Sorry, can I just trade it to change it out as a hypothetical? So he's asserted that he's managing as a prudent investor. Say it's actually all invested in, I don't know, it's not invested for growth in a way that has resulted in massive reduction in income while it's growing. We don't know that because there are no facts on the record. And so we don't know if this 1% actually at all corresponds with the investment strategy that's been pursued.
I guess another way of saying this is that, is it sufficient on summary judgment for the trustee to simply say, I complied with the act. I considered the factors and I made my adjustment in accordance with the MPIA, because that's in essence the bare bones affidavit that's here. It did give one piece of information about the amount of capital growth, and it did give one relative piece of information, one piece of information about relative increase in income in terms of income distribution to the income beneficiary, but it doesn't give anything more than that. And the question is that sufficient, even if it's not opposed, to entitle the trustee to summary judgment on the question on whether the trustee complied with the provisions of the MPIA?
Yes.
Okay, so what's your legal authority for that?
The legal authority there is the burden on the objector to show there was an abuse of discretion.
Okay, so
And there's nothing in Mr. Judson's affidavit that states that Attorney Friedman abused his discretion. All he speaks about are statements from the other trustee and income beneficiary, Denise Levy, that we have no idea that Attorney Friedman ever heard those statements. We have no idea if Attorney Friedman had knowledge of her specific means that may be higher than he may have expected, according to Mr. Judson.
And the summary judgment motion was made before there was discovery, is that correct?
Correct.
Can you tell me whether the adjustment in this case occurred simultaneously with the distribution, or even if there was a distribution?
That is not in the record. We can assume that there was I assume there was a distribution after the adjustment, or else that's the point of that's why you make the adjustment, but it's not in the record.
Can I follow up on just Justice Wendland's point earlier? So Article 7 gives you the power to adjust for tax purposes. I get that you can adjust for tax purposes. You can't invade principle unless there are extraordinary circumstances. You can adjust, you say, because Article 7 says for tax purposes, but can you adjust for any other purposes? Or does that mean it's an invasion of principle? That's what I still don't get that yet.
That's why we have the statute. That's why the statute was passed in 2006.
But when the will actually says you have the power to adjust for purposes, for tax purposes, is there a necessary implication that you do not have the power to adjust for any other purposes?
Yeah, that's my question.
No, in order for the Principal and Income Act not to apply, there needs to be clear language that takes away the power to adjust.
So this negative implication is not enough.
The statute itself even says if there are some limitations on the power to allocate or adjust within the trust, that's not sufficient to take it outside of the statute.
No, what section is that?
That's section F, subsection 4F.
4F, okay, thank you.
So there needs to be a clear intent that there is that the trustee has no power to adjust whatsoever.
So can we go back to my very initial questions? Do you think this falls under, which subsection of 3A do you believe this particular testamentary trust falls?
3A3.
Okay. So the objector thinks it's 3A2, and you think it's 3A3.
I guess if it did fall within 3A2, I still think we would prevail, because if we are saying that the trust is, if the trustee was given a discretionary power of administration, then he would have this power as well. I'm not sure it matters, but.
So 2 you win, 3 you win.
Yes, but I don't think 2 applies, so I don't want to advocate for that whatsoever. It's.
Can you explain to me the distinction between the power to adjust and the ability to make distributions? Because one is clearly tied to extraordinary circumstances, the other is not.
So the power to make distributions, otherwise known as the power to invade, is the situation that is spoken to in the trust.
Right.
This is when the income beneficiary, here the daughter of the settlor, needs the money. If there's dire circumstances, then the trustee has the power to, invade the principal, no matter what the investments have done.
Right.
Whereas the power to adjust is, again, this newly found power in the trust and estates community, passed in 2006, which is a recognition that investment strategies have changed.
Which will result in distributions.
They result in an adjustment or allocation, which may have the
Which
same
result in a
effect.
distribution.
Which may have the same effect as a distribution.
Right.
But
What it does to the person who's complaining.
It's the basis of the power that's different than the power to invade, and it's also the factors that the trustee weighs. We have to remember that in 1977, when this trust was put together, interest rates were 7 to 8%. Now they're not. Stocks issue dividends on a regular basis. Now they don't. The stock market's 40 times higher than it was then. This is a situation where the language of the trust, as seen in Article 7, even if you disagree that that is a more general allocation principle, but the language of the trust is, if there are situations where an allocation or adjustment needs to be made to be fair and equitable to all the beneficiaries, then the trustee should do that. And so, therefore, there's no reason why the power to adjust under the MPAA doesn't apply here.
Going back to Justice Gaziano's question, am I correct in assuming that if an adjustment took place, and let's talk about this one, and it goes up to $90,000, and then that were paid out to the benefit to the present beneficiary, that would be accounted for on the books as a payment of income to the beneficiary, correct?
I presume so, yes.
Okay. So there actually isn't a distribution of principal following an adjustment.
No, it is considered income, correct.
Right, so you move it from one column to another and then say, I'm taking it out of the other.
Right. And remember, this can go both ways. So say we have a stock market crash like we did in 87 or 08, the trustee could decide to move income to principal if it's fair to all beneficiaries.
You had said that it was the petitioner, Mr. Jepson's burden to show that the trustee abused his discretion. What is the legal authority for that? Is that in your brief? If it is, I'll find it. But
Not as clear as it could be, but it's in there. I can give it to you right now. So Section 3 of the Act states that a decision by the trustee is presumed to be fair and reasonable to all of the beneficiaries. And then you'll also have Section 5 of the Act, which discusses judicial review of trustees' decisions. And it shows that it states that the burden is on the party objecting to the trustee's action. Now, that the procedural posture considered in that Section 5 slightly bit different than ours, so I don't want to mislead you in that, but the principle should be the same, that it is the objector that has to show an abuse of discretion, especially where we have Section 3 that says it's presumed to be fair and reasonable.